in a little bit. Oh, now we're starting to record. Uh, most of the last couple of years, not most of it, sorry, let me restart. Over the last couple of years, the division staff have undertaken a number of efforts to help improve compliance. They've done a number of uh, public engagement efforts, workshops, outreach actions. We've had one-on-one office hours. We've had informational items. We've drafted FAQs and other types of pieces of information, but it really hasn't changed the overall compliance rate, which still remains very low. In doing a deep dive and analysis, we've identified a couple of places that we believe emphasize or make compliance worse, if that's the right way to say it. Places where the regulation itself is confusing or potentially contradictory, places where the regulation is just not clear enough to really describe what we're asking for and what's needed, which results in an overall drop off in compliance. And when people do submit data to us, it's often unusable or not in a usable format. So going forward, what we'll present on here are some of the potential revisions. This is, as noted, an informal opportunity for public comment and engagement. There will be additional opportunities over the course of the next couple of months where we begin the formal regulatory update process. There's a very prescriptive set of steps that we have to follow as part of the Administrative Procedures Act. We're not there yet. So this is kind of like an administrative draft where we're putting out a version. We're soliciting early comment and feedback, both here today as well as through written comments, which we'll talk about in a moment. There will be additional opportunities going forward over the next couple of months. And so with that, we look forward to hearing your comments and feedback, which will improve the regulation's clarity and effectiveness. And with that, I'll turn it over to Division Staff Kartiki Naik, who will facilitate for us today. Kartiki?
Thank you, Eric. Hopefully you can hear me. I'm not sure if you can see me. My computer is a little slow right now, but thank you very much for kicking off the workshop, Eric. Good morning to you all. Thank you so much for joining us today. I'm Kartiki Naik, Water Resource Control Engineer at the State Water Board, and I will be facilitating today's staff workshop. As Eric described, this workshop will cover the draft proposed changes to the measurement and also known as SB 88. I would also like to note that board member Sean McGuire is joining us today in Zoom meeting. Next slide, please. Before we start today's staff presentation, I would like to go over some ground rules. This is a public workshop. It is an opportunity for the public to listen, learn others' perspectives and ideas that are being shared. We ask the attendees to listen actively with an open mind, respect others' viewpoints, even if you don't agree with them. Lastly, if you do intend to speak, please stay on point and on time. Let's help everyone have the opportunity to be heard. Next slide, please. So let's go over the logistics for today's workshop. If you're registered for today's meeting using Zoom and are attending using the link emailed to you from the registration confirmation, you can submit questions using the Q&A feature. You may have to click the More button to access it. Staff will respond verbally to these questions during the Q&A section of this workshop following the staff presentation. If you'd like to have any questions answered privately, please send them to our inbox at the email address on this slide. That is dwr-measurement@waterboards.ca.gov, or you may also call and leave a message on our voicemail box at 916-323-9393. We can move on to the next slide. As you can see on this slide, today's workshop is broken up into the sections, and we'll follow this general order. We'll begin with a brief overview of the existing regulation. This includes who is subject to the regulation, some data on the status of the regulation implementation so far, the usability of submitted data, and our previous outreach efforts. Next, we'll talk through the draft proposed changes to the regulation and lay out the tentative rulemaking timeline and next steps for our proposed changes. After the staff presentation ends, we'll have a short break, then an opportunity for questions and comments. We'll address questions asked using the Q&A feature on Zoom. Attendees that register to attend the Zoom meeting will also have a chance to speak. Next slide, please. With that, let's begin our staff workshop with an overview on the existing water measurement and reporting regulation. I will now hand it off to Pablo.
Thanks, Kartiki. Good morning, everyone. My name is Pablo Ortiz. I'm an environmental scientist with the Division of Water Rights, and I'll be presenting on the existing water measurement and reporting regulations. Next slide, please. California has had a long and complicated history of droughts and unpredictable water supply throughout the state. Recently, the historic 2012 to 2016 drought highlighted the need for more accurate water diversion data to manage water during times of shortage. In 2015, the legislature passed Senate Bill 88, or SB 88, establishing measuring and reporting requirements for California's water rights holders and claimants. SB 88 authorized the State Water Board to adopt an emergency regulation requiring measuring and reporting of water diversion. On January 19, 2016, the State Water Board adopted the Water Measurement and Reporting Regulation, which went into effect once it was approved by the Office of Administrative Law and filed with the Secretary of State on March 21, 2016. Measurement data is essential for managing water resources throughout the state. Water supply is highly variable depending on the current hydrologic conditions of the state. Accurate reporting of diversions assists the board with planning and forecasting limited water supplies, processing applications, transfers, and petitions, and protecting water right priority. Next slide, please. So who's subject to this regulation and what does it say? Under this regulation, anyone who diverts more than 10 acre-feet per year must measure and report their diversions and submit their data as an attachment to their annual reports. Unlike general annual reporting requirements, which require monthly totals of diverted water, this regulation increases the resolution of data by increasing the frequency at which people need to measure their diversions and specifying that measurements must meet certain accuracy requirements. Frequency requirements are tiered depending on how much you divert, with more frequent measurements required at higher diversion volumes. The largest users, those diverting over 10,000 acre-feet per year or 30 cubic feet per second during the summer, must also post near real-time data to a public website. You'll often hear people refer to this provision as the telemetry requirement. It's important to note that these applicability thresholds also apply to a combination of water rights, those that divert from the same point of diversion, divert to the same reservoir, or serve the same place of use. Next slide, please. So what has administration of this regulation look like? Well, starting in 2018, we've collected diverters' measurement device reports and files containing their measurement data as part of our annual water use reporting process. We've reviewed thousands of these submissions and evaluated levels of compliance with the regulation. This graph is a simplified look at submission rates throughout the first 6 years of implementation. In green at the bottom are water rights that successfully submitted a file with their measurement data. In gray, those who are subject to measurement requirements, but did not divert water in that specific year. In orange, those who registered a device measurement method or alternative compliance plan with the board, but did not submit their measurement data. And in red, those who failed to report any information on their measurements. As you can see, the percentage of water rights that submitted their measurement data has hovered around 20%, with the majority of rights not submitting data, even when they have a measurement device installed. And that's not taking into account whether that data was collected at the correct frequency, correct accuracy, or whether the required parameters of date, time, volume, and rate of diversion were included in the data file. Considering those factors, the true rate of compliance is likely lower than that 20%. In summary, of the more than 12,000 water rights subject to the regulation, fewer than 3,000 submitted data files in any given year. Next slide. Since the purpose of this regulation is to collect high-quality diversion data for use in water rights administration, it's important that that data be accessible and easily interpreted by the board. So while 23% of water rights may have submitted measurement data, not all of that data can be put to use. Taking a closer look at the 2,700 or so data files that were submitted in 2023, only 185 met the criteria for having descriptive column headers that could be read by a machine without individual review. We received over 1,400 unique data file formats in 2023 alone, making mass analysis of water data, which was the goal of the regulation to begin with, virtually impossible. Next slide. In response to these challenges, the division has spent the past year and a half trying to understand the causes of low measurement and reporting rates and develop solutions to improve compliance. In early 2023, we met one-on-one with several large diverters and consultants to talk about how they are currently measuring and reporting diversions and what barriers they may be facing. Since every water right and diversion scenario is unique, our goal was to start with people who have the biggest impact in terms of diversion volumes and who have some of the most complicated water rights accounting. We also hosted listening sessions with the public, both in person and over Zoom, to hear from a wider audience and better understand the challenges that smaller diverters are facing. Based on the feedback and concerns we heard at these meetings, we began developing a handful of tools and guidance materials to address the issues that repeatedly came up in our meetings and listening sessions. The latter half of 2023 was spent drafting and publishing guidance tools to help diverters when they are submitting their annual reports. We revamped our website to improve the layout and language. We created a suite of data file templates and supporting documentation on how to use them. This included a data template manual and tutorial video walking through how to fill out and upload the data file templates. We wrote a detailed manual guiding diverters through the regulation and translating it into plain language with concise requirements and examples. We produced a frequently asked questions document to address the more common questions we received during our outreach. And lastly, we updated the forms for alternative compliance plans and measurement methods. After publishing this new guidance, we hosted another workshop explaining where to find it and how to use it. Then we hosted one-on-one office hours with diverters to discuss their individual diversion and measurement scenarios and help them come up with solutions to their individual challenges. We also visited the World Ag Expo in Tulare to meet agricultural diverters, answer questions, and highlight the new guidance resources. We appreciate the participation and feedback provided by everyone involved in these outreach efforts, and coupled with the persisting issues diverters have encountered in reporting their measurement data, it has prompted us to think about the regulation itself and ways in which it can be improved. Many of the insights provided by water practitioners have been considered and incorporated when drafting proposed revisions. Next slide. Now we'll hear from Sierra about the proposed changes to the existing regulation.
Thanks, Pablo. My name is Sierra Kennison, and I'm a Water Resource Control Engineer with the Division of Water Rights. This is going to be the bulk of today's presentation, and I will walk you through the main proposed changes to the regulation and explain why we're proposing them. I want to preface this discussion with two important points. First, these are just proposed changes. We have not officially started the rulemaking process yet. We want to hear your thoughts and concerns to make this regulation the best it can be. We've incorporated much of what you've told us over the past couple years of outreach, but if there's something we're missing, please let us know. Secondly, with these proposed changes, the regulation will look substantially different from the existing regulation at first glance, but the bulk of the requirements are the same. We've reorganized the text to be more understandable and translated it into more plain language wherever possible. Some substantive portions of the requirements have changed, and that's what we'll be discussing today. But I wanted to start by acknowledging that the red lines of strikeouts and additions make the changes look much more intimidating than they actually are. And with that, let's dive into it. Next slide, please. Here's a list of the main changes we're proposing to make to the regulation. As I mentioned, the language and structure will be the most obvious change, but there are a handful of other changes that we expect will improve the implementation of the regulation. These include simplifying requirements wherever we can to reduce the burden of complying with the regulation, updating and adding to the definition section to ensure that everyone is on the same page about what we mean when we use different terms. Number 4 here, adding a requirement to explicitly identify where you are measuring, being more prescriptive about how data should be formatted and submitted. Number 6, clarifying how points of rediversion should be measured and reported, changing some of the applicability criteria for telemetry and also adjusting some of the telemetry requirements. Number 8, expanding eligibility for alternative compliance plans. 9, allowing the opportunity to change who is subject to which requirements so that requirements could be relaxed or tightened depending on water availability and the need for measurement data. And finally, a couple of items that are not related to the SB 88 regulation, but will affect chapters 2 and 2.7 of the Code of Regulations. The revised text will require diverters to have an email address on file with the board, and annual reports for groundwater extraction will now be aligned with the water year instead of the calendar year. Next slide, please. Now I know this slide looks really complicated, so let's just go through it one step at a time to see how the structure of the regulation is changing. Next slide. Starting at the very beginning, on the left is the structure of the existing regulation, and on the right is the structure of the proposed text. Next slide. Added and removed sections. I'll start by saying that the request for additional time section, which is section 936 of the existing regulation and highlighted in red on this slide, is being eliminated. The regulation has been around for several years now, and all of the dates mentioned in that section have passed. Additionally, in the proposed revision, we have added 2 new sections highlighted in yellow. These are temporary exemption from measurement and threshold and schedule adjustment. The first of these is brand new and is intended to give some relief from requirements in certain situations, but I'll go into more detail on that later. And for the threshold and schedule adjustment, part of this already existed in the current applicability section, so we've broken it out into its own section and then added to it. And again, I'll talk more about that later. Next slide, please. Moving on, you can see that some of the existing sections have been moved around a bit and some have been split apart and then recombined. So instead of having the applicability criteria for telemetry being buried within the measuring devices section, we moved it to the applicability section, so it's all in one place. And instead of having 2 sections, each describing what to measure, how to measure, and what to submit, depending on whether you use a measuring device or measurement method, we instead created distinct sections for each of these topics, sections 933 through 935 of the revised text. And we also lumped in the device registry, which was the report of water measuring device section, into the overall measurement methodology section, which we'll talk more about in a little bit. And lastly, for this slide, some aspects of the measuring devices and measurement methods sections related more to compliance issues than anything specifically measurement related. So we moved those provisions into the compliance section at the end of the regulation. Next slide, please. And then here we show what's largely remaining unchanged in terms of structure. Maybe some text is changing, and we'll talk about that in the rest of the presentation. But in terms of structure, the definitions section is still its own section. We still have a section for applicability and for alternative compliance, and the content that was in the original compliance section is still there. Hopefully that breakdown helped make the structural changes seem a little less daunting. Next slide, please. So to summarize the structure of the proposed text, it starts with definitions to keep everyone on the same page about what we mean when we use certain key terms. Then we go into the applicability section to define who needs to measure and who needs to telemeter. Then we get into measuring and accounting. This says what you need to measure, how often you need to measure, and how accurate those measurements need to be. In general, the main things to measure are the volume and rate of direct diversion, diversion or collection to storage, and withdrawal or release from storage for each claimed water right. Regardless of how you collect data, those are the key parameters that everyone needs to measure. Section 934 gets into how to measure. We've already defined what to measure. This is the how. Largely, how you measure is up to you and whatever works best for your diversion, but we need to know how you're measuring. So this section talks about registering your devices and completing a report of measurement methodology, explaining how you're collecting data, QA/QCing that data, apportioning that data to different water rights, or applying any conversions or calculations. This section also talks about some particulars like where you should be measuring. After that, in 935, we talk about what you need to submit to us. So you've measured your diversion and you followed your methodology. Now it's time for you to send us a data file and send us telemeter data if that applies to you. This section also talks about how to format your data and how to send it. Then we have alternative compliance in section 936. As with the existing regulation, this section is intended to give extra flexibility in circumstances where diverters are unable to strictly comply with the regulation for a variety of reasons. Then in 937, we get into the new section of temporary exemptions. And we'll discuss in a few slides that we have three main categories for exemptions: diverters who did not divert at all during the year, diverters whose diversion infrastructure was destroyed, and diverters whose measuring devices were destroyed. We developed this section after hearing all your feedback about needing some relief from requirements in certain situations. 938 contains language allowing the board to adjust thresholds for different requirements based on the need for data. In the existing regulation, we could raise the 10 acre-foot applicability threshold if the burden of measuring outweighs the usefulness of the data. We're proposing to extend this concept of threshold adjustment to telemetry and to the measurement frequency requirements. I'll go into more detail on this later on in the presentation. And lastly, as in the original text, there is the compliance section, which discusses the risks of not measuring as required. So that's the new structure of the regulation. We think it lends itself to a much more logical flow and reduces some of the confusion of the existing reg. Again, I want to emphasize that the red line text of strikeouts and added text looks really intimidating. We basically crossed out the whole thing and rewrote it in plainer language, but most of the substance of the regulation is not changing. That being said, though, a few things will be changing, and that's what the rest of this presentation is about. Next slide, please. Wherever we could, we tried to simplify requirements and relax them as much as possible. We adjusted some of the frequency requirements to allow more people to measure a little less frequently, and we adjusted the accuracy standards to be a little less stringent. We also removed the requirement to recalibrate measuring devices every 5 years. After hearing from you during our outreach, we agreed it didn't make sense to require blanket recalibration across the board every 5 years. We understand it could be prohibitively expensive and may have even gone against manufacturer recommendations. So instead, we just require that you send us some kind of evidence every 5 years that your device is still functioning properly and accurately. For some devices, this may still require recalibration, but for others, you could find some other way of documenting the accuracy of your device. To be clear, your device needs to meet the accuracy standards at all times, but you just need to send us verification every 5 years. Next, we modified the definition of qualified individual to include diverters who have attended and passed the University of California Cooperative Extension course indicated in Assembly Bill 589. We also adjusted requirements such that diversions under 200 acre-feet per year are held to less stringent requirements, whereas in the existing regulation, that threshold is set at only 100 acre-feet per year. Also, in the existing regulation, there are a few extra requirements for certain diverters who have storage facilities or who measure collectively as a group. These included needing to keep track of maximum and minimum storage elevations and needing to report consumptive use and other annual water use patterns. In this update, we removed those added requirements from Chapter 2.8. It's possible that similar requirements appear in other regulations or in permit or license terms, but at least for the Chapter 2.8 measuring and reporting regulation, they are no longer included. The changes we're making to this regulation do not change any requirements of other regulations or of permit or license terms, so please be sure that you continue to adhere to any other legal requirements. And as mentioned, we're adding some temporary exemption scenarios into the regulation, but more on that later. Next slide, please. Frequency. So I mentioned that we're simplifying some of the measurement frequency requirements. The measurement frequency refers to how often you need to collect data, and requirements are tiered to reflect the size of diversions. On the left here, it shows the current requirements. Under the existing regulation, whether you measure monthly, weekly, daily, or hourly depends on the size of your diversion. But it also changes based on whether you have directly diverted or diverted to storage. And as you told us during our outreach, this was incredibly confusing. Many water rights are for both direct diversion and diversion to storage, so it didn't make sense to have two different sets of frequency thresholds. Instead, we combined them so that wherever you are authorized to divert, regardless of whether it's a direct diversion or diversion to storage, that total amount determines your requirement. And since the previous frequencies were less stringent for diversions to storage, we decided to use those values. So now, if you divert more than 1,000 acre-feet per year, you need to measure hourly. More than 200 is daily, more than 500 is weekly, and more than 50 is weekly, excuse me, and more than 10 acre-feet per year is monthly. Next slide, please. Measurement accuracy. Similarly with accuracy standards, previously your requirements were based on whether your device measured the diversion itself or the volume of stored water. And then there was a separate, more stringent requirement for lab-certified devices. Those requirements were overly complicated, so again, we did what we could to simplify them. People who had devices before the original regulation took effect are still grandfathered in at the same 15% accuracy requirement. For everyone else, it's based on how frequently you need to measure. So if you measure monthly or weekly, you can be within 15% accuracy. If you measure daily or hourly, you should be within 10% accuracy. This is generally what the existing regulation requires, but it puts it into clearer terms. And we removed the 5% accuracy requirement altogether. No one needs to be held to that degree of accuracy under this regulation. As a reminder, when we refer to accuracy, we are referring to the error regarding volumetric measurements. So it's the percent difference between the volume measured and the actual volume diverted. That definition has not changed, but as a heads up, we did move that explanation. So now it's in section 933 with the actual accuracy requirements instead of being lost in the definition section. Next slide, please. Temporary exemptions. This section is brand new, so let's spend a bit of time going over it. As I mentioned, there are 3 types of exemptions under this proposed update. The first type is for people who do not divert at all during the year. Under the proposed regulation, if you do not divert any water for the entire water year, you do not need to submit a data file. Instead, you'll need to indicate in your annual report that you did not divert, but we do not need a data file full of zeros. The next type of exemption is for people who have had their diversion infrastructure destroyed. If there's been some kind of natural disaster or some other catastrophe that wiped out your point of diversion, you can be temporarily exempt from measuring until your diversion is back up and running. Again, just indicate in your annual report when you were unable to divert and begin measuring again once diversions resume. The last type of exemption is for people who have had their measuring device or associated measurement infrastructure destroyed. If an animal came along and stole your device, or a natural disaster broke it, you can request a temporary exemption from measuring for up to 180 days, with the possibility of extending beyond those 180 days. This temporary exemption is intended to allow flexibility if you need additional time to purchase, install, or calibrate a new device. I do want to point out, though, that this third type of exemption requires you to request it, whereas the first 2 you just need to indicate in your annual report. Lastly, before moving on, I also want to emphasize that these exemptions are limited in scope. You still need to submit an annual report per Chapter 2.7, even if you have an exemption under Chapter 2.8. Next slide, please. The definition section of the regulation will generally remain the same, but we are adding a handful of new terms and refining others for additional clarification. The main definitions we're proposing to change are the meanings of measuring devices and measurement methods. This may sound a bit complicated, so I want to spend a couple slides going over what it means. In the existing regulation, a device and a method are distinct concepts. A measuring device is some physical piece of equipment that measures a handful of acceptable parameters. It outputs raw data, which may need to be QA/QC'd or have some equations applied, and by the end of that process, you'd have your measured value that you'd include in your data file. A measurement method was defined as any other way of measuring. Maybe it involved collaborating with other diverters or using a piece of equipment that measured a parameter not included in the list of acceptable parameters for a measuring device. However it was that you'd measure, you'd end up with your raw data that you might QA/QC or apply some formula or conversion, and the final output would be your measurement data file. But in practice, having these 2 terms was very confusing, and the line between a device and a method was so blurry that it didn't offer any meaningful distinction. Next slide, please. So now we have a revised approach with new and hopefully clearer definitions. A measuring device is simply anything that measures. This includes what would have been considered a device or what would have been considered a method under the old definitions. The output of your device is your raw data. You still QA/QC your raw data and apply any calculations to get the measurement data that you put in your measurement data file. Under the new definition, everything that helps you get to that final measurement data is considered your measurement methodology. This includes all of your measuring devices that help you get data, plus the methodology of how you transform the data. So any QA/QC protocols, any calculations, conversions, formulas, measurement methodology is the umbrella term that encompasses it all, and the end product is your data file. This means that diverters will need both a measuring device to get data, or multiple devices, and a methodology to explain how to derive the numbers in your data file. Next slide, please. In general, the different components that need to be in your measurement methodology are pretty much the same as what was already required under the existing regulation, just put into plainer language and condensed into a single section. You need to provide us information about each measuring device you use, things like the make and model and type of device, and you need to tell us how you take whatever the raw output of that device is and convert it to the volume and rate of direct diversion, diversion to storage, and withdrawal or release from storage. For example, if you have a totalizer that provides the cumulative volume diverted, you can use subtraction to find the volume diverted in each measurement interval, and then the conversion to flow rate will generally be calculated as volume divided by duration of diversion. So you'd tell us how you determined the duration of diversion. Or if you use dedicated electrical records, you could say how you related the electricity consumption to the power of the pump, and then converted it to a pumping rate to get flow rate, and then use the duration of diversion to calculate volume. Whatever methodology you use, the report of measurement methodology is where you tell us about it, including any QA/QC procedures. Do you spot check your data for errors? Do you compare your device's output to another data source to look for outliers? Tell us what you do to prepare your data for submittal. I'll go into more detail in the next slides, but the report of measurement methodology is also where you would tell us how you apportion your data per water right. To reiterate, the methodology is anything you need and anything you do to collect data and to convert it into a data file that you'll submit to the board. We're hoping to have the new regulation take effect by the reporting season for water year 2025. So therefore, we're requiring that all reports of measurement methodology be filed before the reporting deadline, which is February 1st, 2026. And similarly, that all devices be registered by the same date. These will be available as forms on the online reporting platform. I also want to point out that methodologies are subject to review and rejection. Please be as descriptive and as thorough as possible so we can best understand how you are measuring and accounting. That being said, you do not need to wait for an approval from us. Start implementing your methodology right away, and we will let you know if there are any issues. Methodologies are presumed to be approved unless we notify you that it's been rejected. And lastly, and this was implied in the existing text, but we're making it explicit here, that the manner and location in which you install devices or associated infrastructure should not result in a serious or major disturbance to an environmental or public trust resource. With that, let's get into a couple examples. Next slide, please. So suppose you and a group of other diverters collaborate and share devices to jointly measure your diversions. Part of your methodology would explain how you determined the amount diverted under each water right. This could be as simple as a percentage-based calculation. If person A and person B measure water together and person A takes 3 times as much water as person B, then the methodology could say that 75% of the measured volume is attributed to person A and 25% is attributed to person B. It should also note how those numbers were determined and when they might change. The main point is that we want accurate measurements of how much water is leaving the stream, and we don't want to double count water. But we understand that it might not be feasible to be fully accurate when apportioning per water right. So please do the best you can and just tell us what you did and why. Next slide, please. Now suppose you're a single diverter with multiple water rights that divert from the same point of diversion, and you measure them all together. As in the previous example, you still need to apportion to each water right. So you could apportion diversions to your senior water right first, and then apportion to your more junior water rights with any remainder. If you have diversions that could be attributable to different rights or contracts, again, we understand that fully accurate apportioning might not be feasible, so do the best you can and explain in your methodology what your approach is, including all possible rights, contracts, or other sources of water that may be confounding the apportionment. But the most important part is that the total measurements are accurate and that you are not double counting water. Before we move to the next section, I also want to mention that the draft revision says that diverters need to measure the volume and rate of water directly diverted to storage, or withdrawn or released from storage. And to be clear, that's not a new requirement. It's just made clearer in the updated text. In some cases, the easiest way to collect these measurements might be to have a measuring device dedicated to each of those categories, that direct diversion, diversion to storage, or withdrawal or release. But in other cases, you may be able to apportion measurement data based on a calculation. Again, just tell us what you're doing. Next slide, please. Next up, we have measurement locations. In the existing regulation, the language about where you need to measure is scattered in a few places, so we tried to consolidate it in this update. In general, you should be measuring close to your point of diversion. This was in the existing reg, but we clarified further to say that if there are significant water losses from seepage or evaporation between the point of diversion and the measurement location, then you need to account for those as well. So for instance, you wouldn't be able to divert water into an unlined canal and then measure your diversion half a mile down the canal, because that measurement would no longer be representative of what you actually diverted and would therefore not meet the accuracy requirements. We're also explicitly asking you to identify your measurement location. The goal of this regulation is to better understand water availability, which means we need to know when, where, and how much water is being diverted. Without specifying where the measurements are being taken, we're missing that critical component of where water is being diverted, and that makes it really difficult to interpret the data files we receive if we cannot link the diversion data to a point of diversion. Next slide, please. That leads us to the next change proposed for this regulation, data files. In the existing regulation, the language about data file content and format is very vague and just says the data needs to be viewable through Microsoft Excel. As Pablo showed at the beginning of this workshop, that vague language has meant that there's no standardization between data files, which means there's no efficient or systematic way for us to aggregate that data. In 2023 alone, we received over 1,400 different formats, which makes it virtually impossible to systematically and automatically incorporate all of that data into a comprehensive database. Instead, we need a more standardized way of ingesting the data, and that means that we need to use prescriptive data templates. This regulation is not expected to become effective until late next year, so you don't need to worry about this for the current annual reporting period, but next year, as we transition to our modernized online reporting platform, you'll be provided with data file templates for your measurement data. We're also planning to allow direct transmission of data through an API or something similar, and we'll issue more guidance on that in the future. Additionally, instead of just saying, send us your data, we're clarifying that your data file should contain the volume and rate of water directly diverted, diverted to storage, or withdrawn or released from storage, and your data file needs to contain data that is specific to the water right being reported. In general, measurements will be collected at each point of diversion, or POD, so the data file will also contain data specific to that POD. So if a group of diverters measure together, for each point of diversion, they'll need to apportion that data to each water right. By now, this should all sound a bit familiar. We've talked about the parameters you need to measure, the methodology of how you measure them, and how you QC, convert, and apportion data per water right, and the final result is your data file. Also in your data file, we're asking you to identify any measurements of rediverted water. This helps us avoid double counting, which would otherwise make it seem like more water is leaving the stream than actually is. As we said at the beginning of this presentation, we rely on data to make decisions about water management, so we want to make sure that data is as accurate and representative of actual conditions as possible. So if you measure rediversions, please just label the data accordingly. That's the bulk of what you need to know about data files, but another component that you may need to submit is supplementary information explaining your data. This could be information about how you QA/QC'd your data or calculations for apportioning per water right, etc. And this is where it's really helpful and in your best interest to make sure your original report of measurement methodology is very thorough and comprehensive. If you have a very detailed methodology that you already submitted to us, then you might not need to submit any supplementary materials with your data files. But if there's anything that has changed or that you left out of your report of methodology, then you'll need to submit it to us to help us understand how you derived the numbers in your data file from the raw device output. Next slide, please. The regulation says that you need to measure your diversions. The term diversion refers to direct diversions, diversions to storage, and rediversions of previously diverted water. This was ambiguously communicated in the existing regulation, and as a result, many diverters are measuring the rediversions, but many are not. In the revised text, we clarify that for those of you who are measuring points of rediversion, you simply need to label your data as such, as I mentioned in the previous slide, so that we don't end up double counting the amount of water being diverted. The proposed regulation also includes a provision that the deputy director may ask specific diverters to measure their rediversions if they're not already doing so, and if that data is necessary for better understanding water availability. Next slide, please. For telemetry, we made a couple of changes to the telemetry requirements. First, for simplicity, we added the telemetry applicability to section 932, which is the applicability section, so diverters can see upfront if it applies to them. And we made a couple of changes. Under the existing regulation, telemetry applies to anyone who diverts more than 10,000 acre-feet per year under a single claimed water right or under multiple rights that divert from the same point of diversion. It also applies to anyone who diverts more than 30 cubic feet per second between June and September, and to anyone with a storage facility with a capacity greater than 10,000 acre-feet. There's also provision that requires diverters who divert more than 20% of the average monthly stream flow to telemeter their diversions. In the proposed regulation, we're changing the 30 CFS requirement to apply to any diversions, not just those that happen in the summer. This change is expected to impact roughly 150 water rights statewide, and it's intended to simplify the regulation and to prevent impacts to threatened or endangered species that could extend beyond the summer time frame. We're also proposing to remove the stream flow-based requirement entirely, since it was very confusing and difficult to determine which diverters needed to telemeter. For those who are subject to telemetry, the existing regulation requires that data meet the overall accuracy standards of the regulation and that it be posted to a public website every week. From our outreach, we've heard that it's often not feasible or even possible to meet those accuracy requirements on a weekly basis. So for telemetered data, we're updating the regulation to explicitly allow provisional data. You'll just need to finalize it when submitting your end-of-the-year data file. And regarding the requirement to post data to a public website, under the language in the existing regulation, we've received links leading all across the internet. So in this revision, we're specifying that you should instead send the data to our online reporting platform. That way it's all in one place. Next slide, please. All right, now for ACPs. As with the existing reg, the proposed revision includes a section on alternative compliance. The purpose of this section is to acknowledge that strict compliance is not always possible and that diverters may need some extra flexibility in how they meet the requirements of the regulation. For diverters who meet the eligibility criteria, they can submit an alternative compliance plan, also referred to as an ACP, that explains which requirements they cannot meet and why, and what they plan to do instead. In this update, we modified the eligibility criteria so that instead of the limited list of strict compliance is not feasible, unreasonably expensive, would unreasonably affect public trust uses, or would result in the waste or unreasonable use of water, we've added additional eligibility for diverters whose measurement requirements are met by another person, agency, or organization who measures and reports on the diverter's behalf, as well as for diversions where strict compliance isn't appropriate. We hope that these new eligibility criteria help relieve some of the burden for diverters who didn't fit into the narrow set of criteria in the existing reg. You'll still need to justify your eligibility in your ACP and explain how you meet as many of, or how you plan to meet as many of the requirements as possible, but we want to allow extra flexibility where we can. Next slide, please. In general, the requirements for ACPs are staying pretty much the same, though we've reworded the section to be in plainer language that we hope makes it clearer what we need and why. We've explicitly called out water rights that divert water purely for non-consumptive uses like hydropower generation, with the understanding that these diversions are being measured in a different way than most other types of diversion, and that the water being diverted is ultimately released back to the stream. We've also made clearer that diverters who pursue an ACP still need to submit measurement data. ACPs are not a way to get out of measuring altogether. Rather, they are a way of allowing flexibility such that diverters should meet as many requirements as they can, and then explain where there may be shortcomings and what they plan to do instead. Lastly, as with the report of measurement methodology, ACPs are subject to review and rejection, or we may ask you for more information justifying why you need an ACP and how your proposed approach meets the intent of the regulation. That said, you do not need to wait for our approval before implementing the ACP. It is presumed to be approved unless we tell you in writing that it's rejected. Next slide, please. As I mentioned earlier, we added a section about adjusting thresholds. In the existing regulation, the board can raise the 10 acre-foot applicability threshold for the regulation and can also adjust the 20% stream flow telemetry threshold, which, as we've discussed, has been eliminated. In the proposed revision, we're keeping the 10 acre-foot threshold ability and have also added in the ability to adjust the measurement frequency thresholds, determining how often you need to collect measurements, and the telemetry thresholds, determining who is subject to the telemetry requirements. So if we decide that measurements are too burdensome in a given watershed, we could raise the threshold so that fewer people would be held to the more stringent requirements. We have also added in the ability to adjust how frequently diverters need to send us a data file. In general, the requirement is to send us a data file once a year with your annual report, though there is also currently the provision that we can ask for data at any time. In this update, we took that provision to be able to ask for data at any time and turned it into a schedule that we can update as needed. So if we know that we'll end up needing data more frequently than once per year, we could update the reporting schedule to say, hey, we actually need data every quarter or every month, instead of repeatedly issuing requests each month or each quarter for you to send us the data. We just tried to streamline the process a bit. And in the event that we ask you to send us data more frequently than once a year, we've built in the flexibility to allow for provisional data in those cases. I want to try to alleviate any concern about the threshold adjustment section. The intent is to better align the burden of measuring with the importance of those measurements. So if we enter a drought scenario where highly accurate measurement data becomes more valuable, then we might lower the thresholds to increase the availability of that data, though no water rights under 10 acre-feet per year will be affected. But in less severe times, we could raise the thresholds to alleviate that burden. Either way, it'll be accompanied by a thorough analysis, and there will be a noticed opportunity for comment before we adjust any thresholds. Next slide, please. So that concludes the main changes to Chapter 2.8, the SB 88 Measuring and Reporting Regulation. Next, there are a couple of other minor water rights-related regulation changes that we're proposing to include as part of this update. First, we're requiring that each water right holder have a valid email address on file with the board. This requirement could also be met by an agent or employee of the water right holder. We're modernizing our online reporting system, and the new platform requires an email address for data security purposes, so that's why we need it. Next slide, please. And lastly, in Section 930 of Chapter 2.7, which talks about groundwater notices of extraction and diversion, we're changing the reporting timeline to align with the water year instead of the calendar year. All other annual reports were transitioned to be based on the water year a few years ago, and now we're making that transition for groundwater notices of extraction and diversion as well. As a reminder, a water year is a 12-month period beginning on October 1st and ending September 30th. So water year 2024 started October 1st of 2023 and just ended on September 30th of this year. We're now about a month and a half into water year 2025. That concludes the overview of proposed changes, and with that, I'll briefly go over the next steps in this effort. Next slide, please. The presentation slides and workshop recording will be uploaded to our water measurement and reporting rulemaking webpage. Those who subscribe to our measurement inbox will receive an email notifying you once the slides and recordings are online. Additionally, the written comment period for this proposed revision will end at noon on Monday, November 25th, and we're hoping to enter into the formal rulemaking process in December or early in the new year. Next slide, please. Here's an overview of the whole rulemaking process. Currently, we're only at the very beginning, the pre-rulemaking stage. We've released our first draft of the text and are in the middle of the comment period. which, as a reminder, ends at noon on Monday, the 25th. After we've reviewed all your comments and updated the text accordingly, then later this year or early in the new year, we'll release the Notice of Proposed Action to the Office of Administrative Law, OAL, along with the draft regulation text, the initial statement of reasons explaining why we are undertaking this rulemaking effort, the informative digest, which summarizes the changes and reasons, and the economic impact assessment. OAL will then publish the notice in their notice register, which will initiate the formal rulemaking process. Once the notice is published, there will be 45 days for the public to send us any comments or suggestions, and at the end of the 45-day comment period, we will hold a public hearing, which will include another staff presentation going over the regulation and proposed changes. And then there'll be a few more days to submit comments. By summer 2025, after we have incorporated comments, we'll take the text of the revised regulation to an official board meeting. Again, there will be a staff presentation and the opportunity for public comment. Then the board will consider whether to adopt the revised regulation. Once we finalize the text of the regulation, we'll submit it to OAL with the final rulemaking package. They will then review it, and once approved, submit it to the California Secretary of State to be entered into the California Code of Regulations. We expect the regulation to take effect in late 2025 or early 26. That covers all the basics of the proposed rulemaking and the associated timelines. Thank you all for your time and attention. I know that was a lot of material to cover. And with that, I'll pass it back to Kartiki.
Thank you, Sierra, and thank you, Pablo. We do have a 15-minute break planned at this point, but before that, as a reminder, if you have any comments or questions during the remainder of the workshop, please use the Q&A feature on Zoom. If you're not on the Zoom meeting but would like to join to ask a question or provide a comment, please register using the QR code on this slide. Email the link to join the meeting. Lastly, you can submit any private questions or comments to the email listed here, which is dwr-measurement@waterboards.ca.gov, or call 916-323-9393, and our team will answer those questions privately. We will leave the slide up during the break with all the information. With that, let's break for 15 minutes, and the workshop will resume at 11:10 a.m. See you at 11:10. All right. Thank you for joining back. Hopefully everybody could catch a quick break. We'll now begin the Q&A and comment portion of today's workshop. Next slide, please. In this portion, we'll be going over the questions and comments from the Zoom meeting attendees. On the next slide, I'll go through some logistics for this part of the workshop. Can we move to the next slide, please? I'll verbally announce who will be next to speak. So please listen for your name and you'll be invited to unmute on Zoom. Once we go through all the registered participants, we will have a final opportunity for the attendees to raise their hands or submit final Q&A questions on the draft proposed regulation changes. With that, we will begin the Q&A portion of the workshop. Next slide. During this time, staff will verbally answer any questions submitted by the participants in the Q&A section. Please submit your questions using the Q&A feature on Zoom. You may be required to click on the More button to access this feature. There will be another opportunity for Q&A after the verbal comments and questions if something occurs to you while listening to others speak. With that, I pass it on to the team.
Thank you, Kartiki. So my name is Jesse Jankowski. I'm a senior engineer in the Division of Water Rights, and I'm the supervisor of the Drought Planning Unit. I'll be kind of directing this Q&A. We have a number of received questions. Thank you, everybody. So I'm going to go through and read those verbally and provide some responses. And again, feel free to submit additional Q&A during this, and we will cover it following the other speakers. So starting out with the first Q&A received, we heard from the operator of a small seasonal nonprofit water ditch in an economically disadvantaged area with 50% of families in poverty. We do not sell water. We use a natural stream for conveyance. We can measure the volume of the initial diversion, but the stream terminates in Lake Oroville on DWR property. On the way to Lake Oroville, there is riparian usage, percolation, theft that is not prosecuted by state or local officials, and inflow from springs and rain. Precise daily measurements are not even possible. How do you measure usage in that situation? We proposed an ACP, an alternative plan, but never received comments, help, or approval from the State Water Board. Okay, so we have a number of things here, and I do encourage this individual to reach out to staff directly. We'd be happy to talk through individual nuanced situations. But again, if measurement of the volume of the initial diversion is possible, that is what is primarily of concern to meet the intent of the regulation and what is required for measurement. You are not subject to measuring rediversions unless the rediversions conveyed down this stream. You're not subject to measuring rediversions unless the deputy director makes that requirement, and the measurement of the initial diversion is what is outright required under the regulation. I don't know what threshold or what frequency of measurement you're subject to, but if you're unable to meet that frequency, an alternative compliance plan is the appropriate pathway. Again, if you reach out to staff, we'd be happy to talk through kind of specifics on doing so. But as Sierra alluded to earlier, alternative compliance plans do not have to be explicitly approved by the division. This is under the proposed changes to the regulation, but even under the existing regulation, I know it's a little bit vague, but alternative compliance plans are able to be implemented upon submission. They do not require approval, and the division will follow up with folks as appropriate to determine if that ACP, the alternative plan, is not appropriate. But you are, welcome to submit and implement that plan immediately. If there is water theft occurring, that's kind of a separate issue, but I encourage you to report any unlawful uses of water via the Cal EPA complaints portal. I'm going to ask staff to drop a link to that in the chat, but that water theft is kind of a separate issue from this water measurement and reporting regulation. So hopefully that answers that first question. The next question, does SB 88 give the deputy director the right to ask diverters to measure their rediversions? Under the current regulation that is in effect, rediversions are essentially lumped in with all other diversions, and the regulation doesn't have a lot of clarity on specifying and distinguishing these rediversions. So the revised regulation, as Sierra described, does give the deputy director the right to ask diverters to measure these rediversions. And if diverters are already measuring these rediversions, they do not have to change anything. We do just ask, and the revised regulation specifies that these rediversions need to be distinguished from diversions of natural flow to storage or directly, and that we need to avoid double counting so that we're not imagining that folks are taking more water than they actually are if they are including rediversions of previously diverted water. The next question, do the real-time reporting requirements mean accessible to the public real-time or just the State Water Board staff? So under the current regulation, telemetry data has to be posted to a public website. As Sierra alluded to, we have kind of variable ways in which folks do so, and oftentimes these websites are not completely public. But under the revised regulation, the data would instead have to be provided directly to the Division of Water Rights via the online reporting platform. And that platform is still being built and finalized. It will not be public until next year, but that platform will include accessibility of data to the public. So in meeting the regulation, providing water measurement and diversion data, that data will become available through the Water Board's reporting platform. So under the new revised regulation, the data will not have to be posted to a public website. You're welcome to do so, of course, but the data will be transmitted directly to the Water Board via data templates or the online platform and will be made available publicly through that platform. For the next question, for greater than 200 acre-feet per year diverters, consider allowing persons holding T1 or D1 or higher State Water Resources Control Board operator certifications to be qualified individuals. I'm not familiar with those certifications. I'm guessing that may be a drinking water certification. I would ask that you submit that in a written comment to us just to make sure we can track that. But I think it's possible that we may be able to expand that applicability. There are only 2 tiers for the qualified individual under the proposed regulation, but we may be able to add additional flexibility based on operator certifications. Okay, moving on to the next question. As a hypothetical, if a water right license allows for the collection of storage in 2 reservoirs having capacities of 26 acre-feet, the proposed regs will require weekly measurements, whereas the existing regulations were based on the capacity of the reservoir and therefore would have only required monthly measurements. Is this the correct intent of the proposed regulations? Well, to clarify, the existing regulations are based on the total storage capacity. So assuming that you meant to say the reservoirs each have capacities of 26 acre-feet, the existing regulation would still apply based on the total storage capacity of those reservoirs. They're under a single license. But the intent of the revised regulation is to simplify and only make the susceptibility, the subject requirement to do the reporting, the measuring based on the maximum allowable diversions. So rather than the capacities of those reservoirs, the amount of water which is authorized to fill those reservoirs. So if the license does authorize the filling of both of those reservoirs, putting it over 50 acre-feet, it would be subject to that threshold. So the intent is to avoid some confusion based on capacities, potentially multiple reservoirs, and instead base the threshold only on the allowable diversion to fill those reservoirs. The next question, how many diverters are under 200 acre-feet? How many under 300 acre-feet? Would it be sensible to change the daily requirements to diverters over 300 acre-feet? I want to point out that I do not have numbers in front of me on how many diverters fall within these categories, but we do have a data visualization tool that staff have developed to track who is subject to SB 88, the current SB 88 measurement and reporting regulations, and what thresholds they fall under within that in order to be subject to that. So that tool can actually be used to determine who meets these thresholds and who is within those categories. One can look at that tool. So I'm going to ask staff to drop a link to that measurement data submission tracker in the chat that can subject that. That can be used to evaluate those numbers. And as Sierra detailed, under the proposed regulation, the deputy director does have the authority to adjust some thresholds based on information submitted. And I know we have a later question that I'll provide some more information on what the deputy director will consider in adjusting those thresholds. But if there is information that is indicating that it would be more appropriate to adjust a threshold to 200 or 300 acre-feet, the deputy director can consider that, and that would entail noticing and opportunities for additional public comment. The next question asks for clarification as to how to telemeter hourly or daily storage data weekly. We often cannot tell if storage refill water is being stored, diverted to storage, or just regulated, directly diverted until 30 days have elapsed per California Code of Regulations, Title 23, Section 657. That's understandable, and that is why the proposed regulation text has provisions allowing for provisional data. So understandably, you may not know exactly what is going to storage versus direct diversions. The proposed regulation allows that data to be provisional. It may be subject to change based on information, after those 30 days have elapsed. And so we just ask that the final data file submission with annual reporting accurately reflect those distinctions, but the real-time telemeter data is understandably provisional and subject to change in those regards. The next question, is there a set criteria to allow flexibility on the frequency, accuracy, and reporting? And I will direct you to section 938 G of the draft proposed regulation. The text is available on our rulemaking website, and this provides 6 criteria that the deputy director will consider when potentially adjusting a threshold or a data submission schedule. And this includes the amount of water diverted in relation to the stream flow within a watershed or subwatershed, the requirements of any policy, decision, or order of the state water board or a court, the need for diversion measurement information in evaluating impacts on public trust resources, relevant information submitted by affected diverters, federal, state, local, or tribal governments or interested parties, the cost of meeting those requirements in relation to the benefits of the additional information, and finally, whether a proposed adjustment would unreasonably injure public trust resources or threaten endangered or protected aquatic species. So a number of detailed things that the deputy director may consider in adjusting those thresholds. And the earlier section 938F provides that the deputy director shall provide notice and opportunity for comment before adjusting these thresholds or schedules. Next question. Do the proposed regulations require storage rights to meter the amount of water withdrawn for use? Or is a staff gauge or other water level measuring device that captures use as well as seepage and evaporation sufficient, as in the total water removed from the system? The existing regulation does require measurement of water withdrawn from storage, but it kind of lacks some clarity on that. So the proposed regulation very clearly spells that out and does, yes, require measurement and monitoring of the amount of water withdrawn from storage. As long as the measurement methodology properly explains how a staff gauge or other water level measuring device captures that data and how the seepage or evaporation or other information is accurately accounted for in those measurements, that would be appropriate. So it just needs to be properly explained in the measurement methodology that Sierra described earlier. Next question. To be clear, the raw measurement device data is no longer submitted, but rather the apportioned amount. If a point of diversion is covered by multiple water rights for the same owner, the data file will include only the apportioned amount reported under a given water right and not the actual measured meter data. That is correct. The proposed regulation requires apportioned data that accurately represents, ideally without double counting, the water apportioned to each of those rights or to each point of diversion. However, the regulation does explicitly require that diverters maintain the raw measurement data, and we may ask for that raw measurement data to be submitted at a later date. So that data does still need to be maintained, but the regulation does more explicitly require that these apportioned amounts need to be provided. Raw data may be provided at a later date. The next question, I know I have a number of questions from this individual, so I welcome them to reach out to us directly. We'd be happy to have a conversation. But the next question for ACPs, alternative compliance plans, what is the definition of unreasonably expensive? Further, what is the definition of not appropriate? Can you provide examples for each of these? Rather than be very prescriptive in the regulation about what exactly is required to meet these categories, we want to give flexibility for diverters to identify and explain why that applies to them. So I can't really provide a definition of unreasonably expensive, but the alternative compliance plan should ideally include some information about costs and an explanation of why the diverter feels that these costs to do measurement are unreasonably expensive given their unique situations. We know there are many, many unique situations across the state and many ways in which alternative compliance plans apply. We just want plans to thoroughly explain why diverters feel they meet these criteria. Additionally, if measurement is not appropriate for some reason, we want you to define why it may be not appropriate. And as I said earlier, alternative compliance plans do not have to be approved to be implemented, but they are subject to review by the division and could be rejected if division staff and the deputy director feel that these criteria are not sufficient to meet eligibility. I'm going to pause for just a second here. Okay, I have two more questions here. I know we've had some Q&A come in while I was talking. I'm gonna leave those for after our registered speakers because I haven't had the time to review them ahead of time, but we have two more. The next question, can there be relaxed threshold requirements or financial assistance to meet measurement requirements for small, less than 300 acre feet, seasonal nonprofit water ditches that do not sell water and serve an area where 49% of families are officially in poverty? Um, this is the same individual that identified an alternative compliance plan earlier, and I want to come back to that as well. If measurement of diversions is unreasonably expensive based on income or the costs of installing that data, we want to encourage folks to submit alternative compliance plans and simply explain in detail why cost is unreasonably expensive. Ideally, this should include cost estimates for how much it would cost to install measurement devices, and we would like folks need to propose an alternative to complying with the regulation. If it is providing data on a less frequent basis or using an alternate method that is not an explicit device or meter to provide that data, those are valid reasons to submit an ACP. And again, we just want diverters to sufficiently explain in an ACP why they feel that the regulation compliance, explicit compliance would be unreasonably expensive. Also, there are opportunities for alternative compliance plans to be submitted for a group of diverters if folks are collectively under multiple water rights and multiple parties complying in an alternate way. Okay, so the last question that we received prior to the break, telemetry data for diversions that remove greater than 20% of historic mean monthly flows in watersheds with threatened, endangered, or fully protected species, or in the other watersheds identified in the existing regulation 933B4A4, provides valuable data as the board moves forward with Governor Newsom's salmon strategy and developing in-stream flow regulations. Can you explain why this provision was removed from the draft language? Well, the main reason is that this provision was very complex and was never made effective. The original text of the regulation said that this provision would take effect on a date yet to be determined, and such a date was never announced or set. So the provision added no value and never actually went into effect. Additionally, it was overly confusing to base a requirement on a percentage of stream flow, and makes it very complex to determine who is subject to a regulation, especially in smaller streams that do not have regular frequent gauging. And we feel it's more appropriate to determine who is subject to telemetry based on set values. And the deputy director, as I mentioned, does have the ability to adjust these thresholds with specific consideration toward species impacts and public trust resources. We do encourage folks to submit written comments if you are concerned about the removal of this provision, and we will take it into consideration. I do want to go back on, I think it was my response to a previous question. I said that we only cared about initial diversions. I want to kind of revise that. As we've talked about, measurements of rediversions are also important, and we do, in the draft regulation proposal have abilities for the deputy director to request that information. Initial diversions are not all that is important to understanding water availability and of importance for the water measurement and reporting regulation, but that is that in some cases may be all that is required for compliance with the regulation. Okay. As I said, we have some additional Q&A that came in while I was talking or during the break. I'm going to save those for after our registered speakers, so I have some time to take a look at them. Thank you all very much for your questions. And again, encourage folks to follow up with staff directly if they want to discuss any of these things in further depth. Thank you.
Thank you, Jesse. With that, we can move on to the next portion of the workshop. We did not receive any presentations for the workshop, but we do have multiple person panels that have registered to attend and speak. So please listen for your name and you will be asked to unmute. With that, can we have MBK Engineers and Northern California Water Association, particularly Darren Cordova, David Guy, and Kyle Knudsen. Please forgive me if I'm mispronouncing any of the names.
I know we have Darren and Kyle on the line. I'm not seeing David Guy on the Zoom meeting, but I have asked Darren and Kyle to unmute.
Thanks, Jesse.
Yeah, good morning. This is Kyle Knudsen with MBK Engineers. Thank you for the opportunity. And yeah, David Guy had to hop off because he had to go to another meeting, but my coworker Darren Cordova is here with me today as well. So we appreciate the opportunity to provide comments today as we have in the past. We do have a few comments and have tried to tailor or adjust those as you've gone through the presentation. Since we don't know exactly how much time we have, so feel free to let us know if you'd like to follow up later about any specific questions or comments. We understand and appreciate that the division is attempting to simplify and provide additional flexibility, such as when diversions are not occurring and in regards to calibration, so thank you. We do think it's important to note that the division's guidance on data files specifically has changed over time. Thinking back about some of the slides and how the data files come in different formats. During similar workshops at the rollout of SB 88, it was identified by division staff that raw data files were requested. Now it appears that these are changing. We understand and appreciate that. Just wanted to make that note. On kind of a bigger picture, I guess our first real comment is that we understand the division would like accurate and thorough reports of measurement methodology. Therefore, we'd like to recommend that any adopted changes occur well ahead of an October 1 kickoff to a reporting period, so that water users understand the requirements and are prepared for reporting. By the timeline slide in the presentation, it would appear that this would not be feasible until possibly water year 2026, especially for complicated situations that may require legal review, board approval, etc. So this, and along with that, this includes the release of any related documents that may have changed, such as data file templates, the reports of measurement methodology. We assume there'll be a template or a form, any changes to existing forms, like alternative compliance forms, requests for additional time forms, the annual reporting forms, so that all of these can be reviewed by the public well ahead of a reporting period so that everyone is aware and on the same page going into that reporting season. Also, we'd like to better understand how these proposed changes relate to some of the other current or related efforts by the division, such as the pilot telemetry project in the Russian River watershed and the Upward or Cal Waters efforts. Like to understand how those are related, and would there be additional changes, perhaps from the pilot telemetry project to the proposed changes that were discussed today. So with that, those are kind of our bigger comments or feedback, we appreciate being able to continue the conversation on those. And with that, I'd like to dive into some more specific comments that we have organized by the proposed regulations. To hopefully that's helpful to follow along. First off, in the proposed regulations, I think it's under 916. It does still appear that requests for additional time are included or allowed, but during the presentation, it sounded like those will no longer be accepted. So we'd like clarification on that. In 907D, it speaks about an online reporting platform. We assume that this is what the Upward group and the Cal Waters effort is coming up with. So we would hope that that would be available well ahead of that October 1 timeframe that we suggested. And perhaps right now, as I think everyone knows, the reporting forms become available on October 1. We would like to suggest that they become available before then, perhaps as early as August 1, so that water users and the people filing those reports have additional time to compile the very thorough and accurate information that is now being requested of them. We would also, we assume that this new online reporting platform will replace both the reporting management system as it currently exists and what is sometimes called the SB88 portal or the Water Right Form and Survey Submittal portal. We assume that both of those will be captured in this online reporting platform. Moving on to 913 little c, it speaks to if the platform is down or not functioning. Is this something that is expected? And if this were to occur, would there be additional time granted to the reporting deadline? Moving on to 920 little a, it talks or it identifies the reporting deadline, the deadline. It says before each February 1. To alleviate confusion, we would like to suggest changing this language to on or before February 1. More of a minor suggestion there. And then under Chapter 2.8, 932 little b, as presented, it appears that the telemetry requirements have not changed from the existing requirements, which we understood to apply by point of diversion. So we'd like to have that confirmed. 934 little c, which speaks to the measurement methodology deadline. Once again, water right holders need time to prepare these. We assume that the intent is that these would be attached to the annual reporting forms, or are they submitted somewhere else? 934 little f talks about registering of devices. Once again, how does that work? What's the process? Is that on the online reporting platform? 935 little c1 speaks to the data file submission process. We appreciate the division creating an online platform to receive this. We understand that was the original intent of the division, but it just never happened prior to the telemetry requirements kicking off. So since that was not available at that time, water users had to develop their own websites or own methods of meeting that requirement. So we'd like to better understand how this new process will work and if those existing public websites should still remain in existence or not. 935 little c2, once again, just will this platform be available ahead of any deadline where this will go into effect? 935 little f1. The current telemetry requirement, as we understand it, is essentially daily data posted weekly. Is the new requirement hourly data posted weekly? I'd like to have that confirmed. 936 little f. It speaks to the ACP submittal deadline. does this apply to previously submitted ACPs? Can previously submitted ACPs be updated pursuant to the new regulations upon their renewal deadline, perhaps? 936 little j, the ACP data submission. What if it's determined that telemetry is not feasible? Is that still allowed as long as it's explained in the ACP? 936 little L4. It's about the review of ACPs. It references a decision or order, so we're just wondering where in this section it explains that process further. And then I believe the final comment or question we have is 937, which is about the temporary exemptions. We appreciate that being added, and we're just wondering if there will be a temporary exemption form. So that's our last comment, I believe, for today. We do have some other minor ones that we'll follow up with staff about, but I'll stop there. I don't know if my coworker Darren has any further comments or clarifications that he would like to add. Not hearing any, so maybe I'll just, oh, he's saying he can't unmute.
There we go. Thank you, Kyle. I thought those aligned very well with my thoughts, and also just to reiterate, as it relates to the measurement methodology, as Kyle explained, that those can take quite a bit of time to prepare, at least in the experiences we've had thus far, where that similar level of information, it seems, has been requested. But it does speak to the level of information, and the question is, what is the level of expectation that's required? It'd be really helpful to have an example or an understanding, a common understanding from the board and with the water users as to what that involves. And so clarifications in that regard would be helpful. But I do appreciate the board's efforts on this to help clean up the measurement regulation. So well done in that regard, certainly. Thank you.
Thanks, Darren. And once again, thanks for letting me ramble off a number of questions and comments. So appreciate the time.
I want to say thank you both. Appreciate the nuanced comments and detail. I hope we'll be able to touch base with you directly to talk through and make sure that some of those specific questions are answered. And we do hope that you will consider submitting a written comment to very thoroughly document those specific concerns. But we appreciate your attention to the regulation and your time.
With that, we will hear from participants who have noted that they plan to speak. Staff will announce the next speaker. Please listen for your name and you will be invited to unmute. If you also noted that you wanted to speak only if necessary and decide that you would like to, please use the raise hand feature on Zoom under reactions. I will now announce the speakers in order. First, we have David Webb from Friends of the Shasta River.
Thank you, but I had actually marked only if necessary, and I'm not prepared to speak right now. So thank you very much.
Thanks, David, of course. We have Andy Atkinson from Bird Haven Ranch, LLC.
I'm not seeing them on the Zoom platform.
Thanks, Jesse. Pat Neo, Pacific Gas and Electric Company.
Hello, can you hear me?
Yep, loud and clear.
Great. Thank you so much for allowing us to comment here. My name is Pat New. I'm a water rights engineer at Pacific Gas and Electric Company. PG&E holds about 224 water rights. These include post-14 permits and licenses, pre-14 appropriative claims, and riparian claims as well. Our water rights are primarily for power generation, and these are located at projects all across the state, from the Shasta, from upstream of Shasta Reservoir, all the way down to the Kings River, and in many watersheds in between. We've taken an initial review of the proposed measurement regulation text and are kind of providing our high-level comments here today. But we'll also be following up with a written comment letter, providing additional comments in detail. The first item I'd like to comment on is the measurement methodology. Our review of the changes is that measurement methodology has been redefined to really include anything that now is not just a one-to-one diversion to single water right instance. With that, there's the new requirement to submit a reported methodology. Our first comment here is that this appears to be a duplication of efforts that should have occurred during petitioning and licensing processes, and is now resulting in increased burden on the water user. When water rights go through petitioning and licensing process, the water user works with a licensing agent from the state board to outline how water will be reported under the water rights, to make sure that there's no duplicative reporting and that a new water right is actually being exercised. And so this new methodology really should have been established during that process, and for the most part should already be on file with the board. In PG&E's scenario alone, we would be required to submit dozens of these methodology reports in situations that have extensive water rights. I think the most glaring example of this is the Drum Spalding project that we cooperate with Nevada Irrigation District, where together we have over 100 water rights that get condensed down and are all rediverted at a single point of rediversion. Documenting the extensive methodology and iterative process that we use to apportion the diversions in the system to individual water rights would take binders and binders of documentation to provided to the state board to really fully encapsulate. The next item of the updated regulations that we'd like to comment on are the telemetry by claimed right. The new telemetry regulations require the posted telemeter data to be posted by each water right, no longer by point of diversion, and on the in the template provided by state board or to the state board hosted website. In many instances, telemetering by each water right is simply not feasible. You would have to integrate the complex accounting systems that I just previously referenced into that telemetry communication system. And as has already been mentioned by other commenters, it is also in the case where storage is present, you need 30 days of additional data beyond the current date to determine whether diversions take place under regulatory storage and withdrawal or actual storage and withdrawal. And lastly, the regulations are conflicting in the language. And this has been highlighted already, where there's the provision that provisional data can be submitted as telemetered, but that kind of defeats the purpose of what State Board is asking for, because provisional data allows data that has not been apportioned by water right. So the language is a bit conflicting and seems to be self-defeating. The third item I'd like to comment on is the new data submittal requirements. The new data files are required to be separated by water right, separated by point of diversion, identify rediversion, and it is no longer being requested that raw data is being submitted, but rather QA/QC'd final data. Our first comment is that QA/QC data for hourly time steps is an overly onerous burden on the water user. And our second comment here is that to follow up to the request to identify rediversions, looking at the templates that are provided on the State Water Board's website, it's unclear how you're supposed to identify rediversions within those templates. So additional clarification on that would be greatly appreciated. And then I have two more comments here, and these are comments that aren't necessarily focused on updates to the measurement regulation, but things that have continued through from the existing regulation that we think are worth evaluating while the regulation is being updated. The first one is on hourly data. PG&E and the rest of the water user community fails to see the need for hourly data. To this point, there has not been a demonstrated need for hourly data, either through the Water Board's water unavailability analysis tool or otherwise. The USGS, which is the gold standard of hydrographic data, publishes its final records as daily data. It's unclear why the State Water Board needs more granular data than USGS final published records. And lastly, combined with the new data submittal requirements, hourly data of QA/QC'd or QA/QC'd final hourly data requires 8,760 data points to be reviewed and processed per year. That's, again, an overly onerous burden on the water user community. And lastly, our last comment is there's no exemption for non-consumptive direct diversion, specifically telemetry of non-consumptive direct diversion. Direct diversion for non-consumptive uses should be exempt from telemetry. There's no value to the State Board in telemetering non-consumptive direct diversions because the water, and this has already been addressed by staff in comments today, is that the water is directly returned to the system. It doesn't represent a depletion from the system, and doesn't provide useful material in a water balance that can be conducted by State Water Board staff. And further, compliance with in-stream flow requirements for hydro projects cannot be evaluated based off diversion data. There's separate publicly accessible gauges to measure IFR compliance. These are monitored and enforced by FERC. That rounds out my comments on the updated measurement regulations. I would welcome further feedback or in conversations with State Water Board staff on these. And like I said, we'll be providing a written comment letter documenting these by the deadline. So thank you for allowing me to comment.
Thank you, Pat. I appreciate your comment and look forward to the written comments. I did want to just flag in relation to a few of the things you brought up. The new alternative compliance plan kind of pathway, which already existed, but the kind of revised provisions for alternative compliance plans very specifically call out hydropower projects as a good case for eligibility for alternative compliance plans. And there are a number of ways in which the ACP pathway encourages folks to identify where other agencies, such as the USGS gauges that you called out, or other FERC in-stream flow release gauges might be meeting these measurement requirements. There is very clearly a pathway in an ACP to describe that specific measuring is not required because it's already being met by another agency, or because if there's some reason that measurement is not appropriate for a hydropower project. So I do think the alternative compliance plan pathway very clearly calls out some of the cases you identified and may provide some relief where appropriate because those requirements are already being met in some appropriate way. So thank you.
Thanks, Jesse. Thanks, Pat. With that, I think it's time to hear from participants who have raised their hands. So just a reminder, if you've not been yet called on and wish to speak, or if you have additional questions or comments, please use the Zoom raise hand feature. You'll find it under React, and staff will call on you. We already have a few hands raised, so I will call upon Chandra Chilmakuri to unmute themselves and speak.
Thank you. Good morning, just very morning. Thank you for the opportunity to provide comments today. My name is Chandra Chilmakuri. I'm the Assistant General Manager for Water Policy at State Water Contractors. Just for background, State Water Contractors is an association of 27 public water agencies serving over 27 million residents and 750,000 acres of farmland. Our members have long-term water supply contracts with Department of Water Resources to acquire state water project water. We have an interest in protecting state water project water rights and stored supplies, and are supportive of the board's efforts to implement SB 88. We agree with the board staff that the accurately measured water diversion data is critical for managing and making informed decisions about California's water supply, especially during droughts. We understand the intent of the changes is to encourage the reporting of the diversion data and increase compliance with SB 88. We support the proposed amendments that clarify the requirements to measure and report diversions, as many of the draft amendments appear to do so. One area of concern is with the proposal to remove some of the previously required components of a measured methodology or alternative compliance plan. Based on our initial review, some of the proposed amendments to the requirements for an alternative compliance plan seem inconsistent with the statute or provide less than ideal information to the board for administering the water rights. For example, the proposed...
Chandra, I'm sorry to interrupt. I think you might be moving away from your microphone. You got a little hard to hear.
Oh, thanks, Jesse. So can you hear me okay better?
Yes, this sounds better. Thanks.
All right. Anyway, just continuing on to some specific examples. The proposed amendments remove the requirement that an alternative compliance plan demonstrate how it will meet the same measurement frequency and accuracy requirements as other diverters must meet. Similarly, the proposed amendments seem to remove the required need to demonstrate why an ACP or why an ACP is required, or sorry, is warranted. The proposed amendments remove the statutory requirement that state board make a finding that the ACP as a modification of measurement requirements is warranted. The proposed amendments permit implementation of an ACP unless and until the state board disapproves it, which opens the door to ACPs that fail to meet statutory and regulatory requirements. The proposed amendments may potentially permit ACPs that fail to measure or report diversions at all. Again, we support the clarifying and streamlining amendments that meet the statutory requirements to accurately measure and report diversions. We would like to work with the board staff on the proposed amendments to ensure that the ACP regulations are consistent with the statute and allow the board to better monitor and enforce water rights, especially in times of drought. Lastly, we request additional time for reviewing and analyzing the proposed draft amendments and to provide helpful written comments. Thank you.
Thank you, Chandra. I appreciate your time. I wanted to respond just slightly on the ACP issue that the division does still have the ability and will be reviewing ACPs and does have the ability to reject ACPs if they do not meet the intent of the regulation. Thank you.
We have Laura Parker next.
Hi, can you hear me okay?
Yep.
Okay, thank you. My situation is the opposite of Chandra. I am just a private homeowner, recently retired, who bought a property that had water rights on it. And I have been reporting as required but I have this dinky little creek which is weeds, for 8 months out of the year. And I feel like I wonder why I'm required to report at all. Then I looked at that water rights data tracker link you put on there and see all these people that never bothered to report. And I do it just because I'm so concerned that you're going to say, well, I don't deserve water rights if I'm not using them, but it's, it's such a tiny amount of water. I wonder, is there some process where I can ask if I can be removed from tracking because it's just a dry creek bed most of the year?
Hi, Laura. We certainly understand that it's not easy for everyone to comply and that the regulation does place requirements. If you are not using 10 acre feet per year, you are not subject to the regulation. However, if that water right on your property falls within that, it is allowed to divert that much. It's a permit or a license. That is why you would be subject to this regulation and present in the tracker. If you are not using that water right to its fullest and you do not need that much water, and I don't know about your specific situation, but if it's a water right permit or license, you do have the ability to do what is called a partial revocation, which would be a way to basically decrease the size of your water right to only the quantity that you would require. This would thus place you below that 10 acre foot threshold and would not place these measurement requirements on you. I don't know if you file a statement of water diversion and use, but there's also a way to submit a revised statement if you do not need as much water as what was reported under a previous owner of that water right or claim. So Laura, I'd ask that you reach out to staff and we can discuss with you what might be best for your personal situation.
Okay. I think back in the day that there was more water available, and because I've been told there were fish in the stream, and so it sounded like a much more viable water source back in the day. But it's, we have El Dorado Irrigation District right down the road, and I believe over the years that the flow has decreased quite a bit from that company and from just other people. The population increased from when the property was first established. So I'll email and ask for a consultation.
Thank you for your time, Laura. Appreciate your attention and thoughts.
So if you don't report as you're supposed to, what happens to you? Because I've always been good about reporting.
I'm sorry, you're asking what happens if you do not report?
Right, because I see that list and I see all the people that didn't report like they were supposed to. So what is the...
Okay. Yeah, so there is some nuance, and this is, I want to highlight a difference between there is the annual reports where you have to, on an annual basis, say what you diverted each month under your water right. And many of the people in that list likely submitted those annual reports, but that list, the reporting, the measurement data tracker is specifically if they submitted the measurement device information and the measurement data files required by this measurement regulations. So there is kind of a spectrum of compliance, and just because they're on that list and listed red does not mean that they did not submit the annual report. That list is specifically highlighting compliance with this SB 88 measurement regulation about installing devices and providing measurement data that is on a more frequent basis than that monthly data in your annual reports.
Okay. Thank you for that clarification.
Absolutely. Thank you.
We have Justin Fredrickson next.
Yes, hello. Can you hear me?
Yes, we can.
Okay, great. My name's Justin Fredrickson. I'm Water and Environmental Policy Analyst at the California Farm Bureau, and this is a lot of information. We'll likely do written comments that will be more nuanced, and we'll attempt to be more technical too, although this is so technical that you almost have to be an engineer, which I'm not. However, I wanted to just make a couple of general comments. One is, that there's good intent here with this regulation, things like simplifying the recognition that the process as it is and as it has been is so complicated that I think that in large part, that is a lot of the reason for some of the quote unquote non-compliance. If you look at the compliance numbers that you've presented, the basic requirement of reporting something is met by and large for the most part. So what you are calling non-compliance is actually partial compliance. And so most of that non-compliance, quote unquote, is actually that someone just did not upload a data file. And then another big chunk of the non-compliance is that there was not a method specified in the manner required. But as far as, people making a good faith effort to report something, the numbers actually do not look so bad. And so I think there's some kind of a silver lining there. And I think it's somewhat of a mischaracterization to say that, there's just massive non-compliance. It puts a misconception out there. So second thing I'd like to say is, so I see when listening to the participants in this workshop, a lot of them are very large, so we heard comments from PG&E, we've heard comments from the state water contractors. I can tell that a lot of the people on the call are engineers or consultants, and so paying close attention to this. We also had comments from NACWA and their consultants. And, not to take anything away from that, but the folks that I'm more concerned about, sitting where I do at Farm Bureau with lots of small diverters and people who do not have engineers and do not have consultants and may not even know about this call is, what happens to all of them. And so I think that I had posted a comment in the questions and answers. I'll restate it in different words. It's regarding public outreach, public education, communication, availability of technical assistance, and also availability of training, like for the, I believe it's called a qualified individual, which does not have to be an engineer, can just be a person who's taken a training course. But the amount of training that has been provided is very, very small in relation to the number of people being required to comply with this regulation. And so that I think if there was some way to make that training more available, more widely throughout the state, perhaps in video form, some kind of a virtual training that people could go through and then download a certificate. I think that could help tremendously. Another thing that's happened in the last year, and I'll wrap here with this, is I believe a month ago or so, there were automatic late penalties adopted as for reporting late. And so it remains to be seen what effect those late penalties will have. One thought that I have there is that these mailings of, if there are late penalties assessed, and also as water rights annual water rights fee bills are sent out, I'm wondering whether you are communicating with the folks who are being who are paying these fees and who are, possibly going to be assessed late fees as to how they can come into compliance. What means are at their disposal, where they can get assistance with this and training, technical assistance, and also alternative compliance plans. I'm going to take back what I said and just add one more thing. One of the huge successes that we saw early on with this SB 88 requirement was in the Delta with the alternative compliance plans that were put in place down there with the assistance of the Delta Water Master that they have in that area. And so we went from an area where reporting by lots and lots of small diverters had always been problematic to almost, 90 or 95% compliance. How did they do that? They used evapotranspiration, and it looks like it's working great. So one of the questions I have, or hopes I would have, is that there could be more blanket approval of ACPs for small diverters who are not having a huge effect on runoff system at the system level, and but who could be very challenged to comply, to the T with all of these highly complicated regulations. So I don't know. Thank you for the opportunity to say all of that, and we will be looking at the regulation and continuing to engage. Thank you.
Thanks, Justin. I did want to jump in and kind of offer some responses to a couple of the statements, and not just yours, Justin, but a couple of the others that we heard throughout. The main thing I want to reiterate is that these are not new regulations, right? These regulations have been in place since 2016. And I think what we're trying to do with this update is get to a place where, one, it's easier. I don't want to say it's easy. I want to emphasize easier, right? It is a complicated topic. It is a complicated request. And by some respects, it's always going to remain complicated. But you look across the entire Western United States, and every other Western states has pretty robust metering and measurement requirements. A lot of our original ones were modeled off of these other states. They've had them for decades. California's been the only one for decades and decades that doesn't have a metering and measurement requirement up until 2015, 16. So, we're doing what every other Western state has been doing for a long time. We're trying to get there. And we do see massive noncompliance. I agree that a lot of that noncompliance is not intentional, but it's still noncompliance. It's like saying, well, I tried to fill out my tax return and I got part of it done, so shouldn't that count anyway? No, it doesn't. We appreciate the effort, but we still need to get to that point where it's fully representative of what needs to be submitted and what should be submitted. The updates that we're proposing here are an attempt to make it easier for the smaller diverters in particular. It's an attempt to make it easier for places where an alternative compliance plan should be able to cover vast areas. So specifically getting to hydroelectric facilities for PG&E, SoCal Edison, SMUD, related hydroelectric integrated projects that, as highlighted, could include dozens or more points of diversion. And I'm looking at my notes over here. But going back, these aren't new. We're not starting from scratch. And so a lot of the comments about, the methodology requirement may be confusing. Take a look at the regulations again. We'll see if we can add some clarity, but it's an attempt to get people to summarize what they're already doing. It's not starting from scratch again, or it shouldn't be starting from scratch. And it's an attempt, a possibility, a pathway for people to say, this is what I'm doing. This is how I'm approaching it. This is how I'm trying to capture how I'm measuring and metering my diversions going forward. Another point I want to raise at the end, I think, Justin, you referenced the late fees. Late fees do not apply to SB 88. It only applies to your annual report. So as of right now, nobody will be getting a late fee assessment for SB 88 metering and measurement regulation components. Just want to make that clear. It could be something we look at in the future, but as of right now, we do not have that set up in our fee regulations. It's only for the annual reports. And it is important to distinguish the difference between annual reports and the SB 88 reports in particular. And then lastly, I want to talk about the public outreach. I agree that we need to do whatever we can on the public outreach engagement component to make things easier. But we've also been doing it for now 3 years. And Connie, Jesse, the whole team that's on here today, has done dozens of engagement efforts. We get very low attendance, we get very low compliance. We do record these, we have them posted. We've specifically reached out to different groups, we've had templates. And so I think we've taken the outreach component largely as far as we can one-on-one. Of course, we're going to continue to engage, and of course, we're going to continue to do whatever we can to make the information as easily accessible and understandable as we can. But, of the 12,000 water rights that are probably subject to SB 88, we're not going to be able to have one-on-one engagement with every single one of them. And at some point, we need to kind of look at tools that will help us engage compliance and make compliance easier. One of the questions that was in the Q&As was related to, do we think the more prescriptive elements will actually improve compliance? And to a degree, yes. I think what we've heard in all of our engagement that we've done is that people don't really understand the existing regulation. And fair enough. So when they submit information to us, it's the wrong information. It may be formatted incorrectly. It may be sometimes just the wrong document entirely, because no one really understands what the requirements are in the existing regulation. Again, I'm greatly paraphrasing. Many people do understand what the regulations are, and they take great care and effort to submit that information to us. But there's still challenges and even difficulties then. So I don't want to minimize the work that people are doing to comply. I do recognize that a lot of people do try, but even trying sometimes still doesn't get them all the way to fully compliant. So lots more to do on our end. We're trying to make this simpler and easier. Again, it's never going to be just completely easy, but it's also important data, right? We do need to understand at a little bit higher resolution, especially in particular watersheds and for larger diverters, the timing and the scope and scale of diversions in a way that help us better manage the resources, particularly during drought. It's not just during drought, it's also things like groundwater recharge, right? All these new permit applications that we might be getting to expand recharge and other new applications that may be coming in, helping us understand the timing, scope, and scale of diversions feeds directly into all of this work that we're now being tasked with doing. So just a quick couple notes there. And again, happy to get additional comments and do really appreciate Justin and others weighing in today. So with that, I'll turn it back over to Jesse.
Yeah, thank you, Eric and Justin. Appreciate your time and your comments. I was just going to highlight that, that previous slide with the stacked bar graph, we didn't call that compliance. That's the regulation implementation. And yes, of course, there's many categories that diverters fall into, and many are making a very sincere effort to meet the requirements of the regulation, or many may be not diverting, and that's why they didn't register a device and submit a data file. So we hope sincerely that these proposed revisions are going to help ease that implementation and give us data that fits into those categories, that would bring those categories into, fully having data that the division is able to use to manage water rights and to understand water demand and water availability. It's really bringing those categories together, where with data file templates and additional information and alternative compliance plans, we're able to actually receive data that we can use, rather than that higher part of the funnel, which is data that is, unusable for the division's mass analysis needs. Thank you.
Thank you, Jesse and Eric. And I think that was the last participant that raised their hands. So we do not have any speakers anymore, but we do have a bunch of Q&As. So let's take a quick bio break, a 10-minute bio break, and we can return at 12:30. Let's round it out. Thank you. Thank you for joining back for our last Q&A portion of this workshop. And I will look to Jesse and staff to answer any additional questions submitted via the Q&A feature. Thanks.
Thank you, Kartiki, and thanks for those that are still listening in or on the Zoom meeting. I want to acknowledge we did get a Q&A feedback that going through these Q&As in detail was, it did consume some time. The purpose of this workshop was to answer questions from the public that were submitted. So we were endeavoring to be able to give space to answer those questions, and especially hope it's helpful if others have those questions. But we do appreciate everybody's patience as we work through those Q&A before the registered speakers. So I'm going to go through the additional pending Q&A here. The first is that it was said during the presentation that the Division of Water Rights might develop an API for submitting data. I would like to see demonstration Python code for submitting the data and a testing space to verify that my interaction with the API is working correctly. This is still all coming. This platform is not live and available. An API was mentioned as one example of an online reporting platform. The details of this future Cal Waters reporting and data platform are still being worked out. I encourage you to reach out to our Upward program staff. These are the folks working on this modernization of water rights data systems, and they do have an advisory group and technical users who are reviewing and going through some of these things. We do not have a platform at this time, but certainly, a testing space would be available to make sure that stuff we receive and interactions are flexible and workable for users. The next question regarding the updates to telemetry requirements. Are these volumetric thresholds attributable to the actual diversions or the permitted diversion volume? I'm going to point you to the definition of maximum allowable diversion amount. That's in the first definitions, section 931 of the proposed regulation. So these telemetry thresholds are based on the maximum allowable diversion, which is for a water right permit, license, registration, or stock pond. That is based on the authorized water right, commonly known as the face value. So this is the permitted diversion volume. For a pre-1914 appropriative, riparian, or other type of water right claim documented in a statement of diversion, this maximum allowable diversion amount is based on historical maximum diversion amounts or the maximum anticipated diversion amount. So if you know you are going to be diverting over 10 acre feet this year, you are subject to the measurement requirements. Or it is based on the historical maximum amounts previously diverted under that statement. This makes it more clear how we are able to determine who is subject to the regulation, and makes it clear for diverters as well that it's not based on what you're actually diverting, but based on what you are the maximum amount you are allowed to divert under your water right. And as I discussed, there are options to revoke appropriative water rights or do a partial revocation of these appropriative rights if your actual needs are considerably lower than the entitlement of your water right. And I think we have some additional questions that'll cover some of this material. The next question is the change from 5-year recalibration to 5-year evidence of proper functioning is appreciated. Could staff provide some examples of what this might look like? Perhaps for direct diversion measured with a flow meter, or a diversion to storage measured with a staff gauge. It kind of depends on the device. If it's a staff gauge, make sure the base of the gauge hasn't sunk or that sediment hasn't built up. For other devices, it could be documentation from the manufacturer that the device is guaranteed accurate for a certain number of years. If calibration is necessary to ensure the continued functioning of the device, you can do that. But it's, again, up to the qualified individual that is responsible for maintaining and installing these devices. So the proposed regulation is being less prescriptive about a defined calibration interval and more comes down to the diverter or the qualified individual certifying that the device is continuing to properly function. The next question, if you didn't divert 1 year and report that you did not divert, do you run the risk of losing your water rights because they were not used? And I think we talked a little bit with this commenter earlier. I want to note that the revocation process, the losing a water right for non-use for a period of 5 years or more is subject to various defenses and a very specific public process for revocation. That water law, that part of water law is totally independent of these measurement and reporting regulations. Next question. For clarification, telemetry data under the proposed regulation can still be posted in a public website. For example, CDEC and the State Board platform is only offered as an alternative. I want to clarify that the proposed requirement is that the data must be transmitted directly to the State Water Board, either via an online reporting platform such as an API with direct data transmission or via submission of data files. You are certainly welcome to still post this data publicly via CDEC or other venues. And it should be fairly simple to take data from CDEC and turn that into a data file that can be submitted. But the proposed regulation text does require that the data be transmitted directly to the board. That's not an alternative. That is required. You're still welcome to post it publicly to CDEC or other sources, but the data has to come directly to the board. Okay, next question. We covered a little bit of this. I noticed there's an added definition for maximum allowable diversion amount. In regard to riparian rights, it appears that the maximum historic volume or maximum anticipated volume can be defined as the maximum allowable diversion amount or applicability with the regulation. If a diverter is now using less water than what is claimed on the initial statement and has no plan to use the initial claimed amount, can the current maximum water use be used to determine the applicability with measurement requirements under the regulation? We do currently have guidance under the existing regulation with respect to these claims. We are primarily concerned with what a diverter is going to use and what the recently used amounts are. However, that maximum allowable diversion does encompass that historical amount. There is the option for diverters to file a revised initial statement of diversion use to report the lower diversion amounts if the historical amounts are not representative of existing and planned diversion volumes, and thus they're not subject to the regulation. But I would direct folks to the measurement and reporting manual on our website, which has some further guidance regarding who is subject to the regulation in these cases. We have a number of questions from the next commenter, and I want to request that they reach out to staff to really talk through some of these detailed questions. I think broadly, I'll go through the broad strokes of these final 3 Q&As, but I'm not going to read them aloud, and I do would really encourage this person to reach out to staff, and we can have a one-on-one question to answer your questions and what seems to be your nuanced situation. One relates to the initial amount diverted versus return flows, and how the State Water Board is making decisions regarding how much is removed. Water removed and diverted from a stream is important and impacts water availability for those downstream and can impact public trust resources. That's why diverters are required to report the amount that they are diverting from the stream and not just the amount consumptively used. But if there are significant returns or losses or situations in which it is not appropriate or necessary to measure the initial amount diverted, that can and should be explained in some alternative compliance plan. But water removed from the stream via a diversion is still critical and very important to be measured under this regulation. Next was regarding reporting frequency. Every situation is different. People might just be leaving a headgate open to divert water daily, but every situation is different. And if they are diverting an amount of water that makes them subject to the regulation, they need to either comply at the required frequency or submit an alternative compliance plan to comply and provide data for a different frequency. Leaving a headgate open to divert every day is still diverting on a daily basis, and one measurement methodology could be to say that you go out in the field and you read a flume or a staff gauge every day, and that is how you meet your daily measurement requirement. So he's still required to report at that threshold or that frequency unless you have an alternative compliance plan that states why that's unreasonable. Finally, accounting for water usage through evaporation on storage, there's a reason that diverters must report water diverted to storage and held and released from a reservoir. So that relates to that. This individual asked, and I will ask staff to respond to that. We have an email. It should be on the next slide, as well as a phone number. Staff will respond immediately to contacts received through those ways. And imagine we might be getting an influx around this workshop, but we do want to offer to meet with folks to talk through these individual situations. So it's a DWR measurement box and a phone number. You'll have to leave a voicemail with the phone number, but we will respond to that voicemail. We're actively checking those. So thank you. And I believe that is all of the Q&A that we have received. Appreciate everybody's time.
Thank you, Jesse. The information that Jesse talked about is on this slide, along with a few more helpful links. So the first link and QR code will take you to our rulemaking webpage, where we'll post our future rulemaking documents, presentation slides, and recordings. You can also sign up for our email list to be notified of any updates on the regulation and the rulemaking process. The second link and QR code will take you to the water measurement and reporting regulation webpage. There you will find information on existing regulations and useful compliance assistance information. On either side, you can subscribe to our email list to be notified of any updates, including when the formal rulemaking process kicks off. And again, you can send an email or call our phone line with any questions or comments. Just a reminder, the written comments on the proposed revisions are due to this email on this slide, which is dwr-measurement@waterboards.ca.gov by noon on Monday, November 25th. We hope this workshop was informative. Thank you very much for your participation, comments, and questions. And thank you for participating all the way through to those that did. Have a good rest of your day.